Yes.
But it's echoing up. Echoing my voice. हाँ अब ठीक है सर आप अपना प्लीज कैमरा ऑन करिए
Okay. Am I audible to you?
yes sir you're
Yes, yes,
audible
yes.
yes sir
Ah, correct.
so thank you so much sir I can see
It is
there are
everything.
lots of people who have joined us today
No issue. It is an electronic board. Takes time,
yes
especially
it's
for the elder people to understand it.
it's completely okay sir it's worth wait so assalamu alaikum everyone I can see there are lots of people joining us today I welcome you all on behalf of the podcast team and my name is Zuran Bukhari. I am the organizer of this event, and
So
I
yes,
will take pride and honor and privilege to introduce our distinguished guest speaker, who has also been the former Chief Justice of Meghalaya, Mr. Yaqoob Mir. There are loads of things that he has done in his life. On the top of my head, he has been the additional district judge in 2007 in Jammu Kashmir High Court. Then you have also been the Chief Justice of Jammu Kashmir High Court for a month in 2015 from January to February 2015 and now you have also taken charge of the chairperson selection committee under juvenile justice rules Jammu Kashmir so even after after seeing whatever you have achieved in your life and the way you speak and the way you are so kind and how you speak how you spoke to me when I called you I was like how can a person be like this after achieving so much in his life so thank you so much for joining us today in this little for thank you so much for having us
thank you very much.
it's an honor to have you here sir and it's thank you so much for gracing us tonight with your presence so thank you so much and the stage is yours
So nice. Am I to start or should I start?
yes sir
Yes, sir.
please
Yes. Dear friends, all of you being the legal fraternity. So that was a basic motivation for me to speak to you on the insistence of this Bukhari. And I've also happy that had is also there, a well-known figure. Also, thanks for listening and organizing the program. The topic we have chosen is evolution of arbitration. Basically, this arbitration has its origin not from the day certain enactments were made, but from the very beginning. In olden times, what used to happen when in a particular mala, in a particular town, some dispute would arise between two parties, then they would the elderly people of the mala or the town, they would resolve their dispute, settle their dispute. This is basically the point. Then we'll see that if cases has cases from the king's command who had decided rather settle the dispute between two mothers claiming right from that day, they started settling the commercial and other domestic issues by having recourse to this methodology of arbitration. Then in the year 19, year 1697, in England, this concept of arbitration was introduced. And then in 1972, 1770, in India, arbitration concept was introduced. And the first arbitration act was passed in 1800 by a flux of time facing the different strategies on different then a new enactment, Arbitration Act of 1940 came into in British era. Gradually, when there were difficulties faced by international community or investment, they were hesitant that increased duties there, which otherwise are always inevitable in commercial matters and commerce matters. Then there was unilateral. There was a net is met together how to evolve the process of resolving may arise out of intertrade or taking care of that situation and other challenges faced at domestic arbitration act of 1996 was enacted. The object and purpose of arbitration is to minimize time and to minimize expenses and to resolve the disputes at an early stage. That was possible only by creating an atmosphere of confidentiality and credibility. Now, with the enactment of Arbitration Act 1986, trust change were which in fact were based on the concept of UN General Assembly resolution and the municipal law. This is basically how this arbitration evolved by a period of time and by facing different challenges at different times, new provisions were new acts were enacted, and so many provisions were introduced so as to see that this is a viable, most efficacious remedy available to disputing parties. This is basically everything this has developed. Concept has developed, platform it has reached to this point. Even after 1996, so many amendments were made in the Act so as to make dispute resolution tangible. In the Legal Society Act, in the various modes and methods of dispute resolution, this type of resolution was treated to be more efficacious, and it has yielded high results. Maybe there may be some shortcomings so as to create confidential trust from among the different stakeholders and to invite the international level invest in the country. Earlier in the Act of 1940, there was no there was no provision for international arbitration, but now under Section 2, it has been included. Now the scheme of the how it is more beneficial, efficacious, and more convenient. If we see in the background of objective, objective is normally to avoid prolongation of the litigation, involvement, to avoid adversarial litigation. This act provides that it two parties having an act and having some commercial relationship. If dispute arises, then they have the option to give no disputing party can give notes to other side, that is go to the arbitration. If he doesn't, then he has the provision of going to the court or referring to the arbitration. He has to wait 30 days of response. No response there, then it will go to the court. Now the court means which court? For young lawyers, some to understand what the court means. There are different courts. It is specifically mentioned as civil court of appeal jurisdiction, which also includes high court and civil or jurisdiction. As you know, all state high court have the original civil jurisdiction, but high court of Kashmir has original civil jurisdiction. This is only in cases that application can be applied. Once an application, there's another person requires to be relief, relief, then he has the power of Section 9. He can move the court for grant of. But once matter is
Everything you read, sir.
then the mention of the ceases. Then it is the you can conduct such application. But that is not mean that court is power because arbitration has powers under Section 17 to grant in case needs. But in case situation arises that under Section 17 is not applicable, then in that circumstance they can again go to the. Then there was another issue, whether seat of arbitration will decide the jurisdiction or something different. It is still a burning issue for the Honorable Appeals Court. In some cases, we held that where the seat of arbitration is located, that's has the jurisdiction to deal with the arbitration.
I'm sorry to interrupt you here, sir, but your voice is not voice is breaking. You're not audible clearly. Uh,
Uh,
if you could just join us again, or if you check your internet connection.
very connected. Yes, am I audible?
Yes, sir, very clearly
Yes,
now.
yes, 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 yes,
Yes,
sir,
sir,
yes,
very
sir.
clearly
Yes,
now.
sir.
Should I continue?
Thank you so much, sir. Sorry.
No,
Yes, sir, please continue.
These things are new to us. It will say take some time, connectivity, internet connectivity, other things.
Sir,
So-
it's worth it. It's really worth it, sir.
sometimes they say don't talk to them. Anyway, I'll continue with it. Basically, I was just speaking about what is the scope of Arbitration Conciliation Act and why it is a dispute of friendly, dispute resolution friendly. We have other provisions like section when an arbitrator passes the award, arbitrator has a limitation. That is section 29A, which provides that an arbitrator has concluded the arbitration within a period of 1 year. But however, if it doesn't happen, then with the consent of the parties, it can be extended up to 6 months, even 1.5 years, it has to be concluded. Then, of course, there is scope for extension of time, but that has to be based on a sound reasoning, not on a casual approach. That's how this Arbitration Act, Conciliation Act provides for a superior uh, scope for resolution of the disputes. Under section 34, if a person is aggrieved by the award, then there is also time limit for filing the application under section 34. In case of other states, it is some 3 months, but in case of state of Union Territory of J&K, it is 6 months time. Then there is only one appeal against available against that order. If a section 34 application is disposed of, the aggrieved party has one remedy, that is to go in appeal. And there is no second appeal provided under the act like it is in civil court, civil laws, under civil code of civil procedure, but under Arbitration Conciliation Act, notwithstanding the provision of second appeal in the civil procedure code, it is not applicable to arbitration cases. That is how care has been taken for just minimizing the scope of prolonging the arbitral proceedings. Then there is another scope for it. Why it has been so? Once a meeting was held at the international level, most of the nations were hesitant in investing in India because they had an issue of facing the long-run litigation. You know, when there is an adversarial litigation, civil suit, there are so many procedural hiccups, then there are so many technicalities, then there are so many forms available, so many remedies available. They were afraid of that in case they land in litigation, it will be very difficult for them to come out of it for years together. In order to give them the full confidence that we are doing the work, we have introduced that, introduced certain provisions, amended certain provisions, so as to suit their requirements also. Now, what is the impact? Impact is huge because when there is investment, trade, and commerce flourishes, unless we guarantee someone outsider at international level that we are a country where we can provide you a superior remedy, only then they will have faith in our system and they will come forward and invest. These are the basically what was the evolution of this and objective. Objective, to be precise, to say is to provide prolonged litigation, and then arbitration is the preferred mechanism for settling the dispute. Global growth strengths, strategies, and economies have also recognized this mode of dispute resolution. This first Indian Arbitration Act, 1899, was fundamentally based on British Arbitration Act of 1899. There the position was different. Arbitrators were to be mentioned in the agreement itself. But now situation has altogether undergone change by the latest amendment, which provides that in agreement or in a contract where there is an arbitration clause, the matter has to be deferred to the arbitrator for resolution. I think these were the issues which were to be addressed. Anyway, you want me anything more to say on this arbitration?
Sir, I think now we will open the floor because primarily our focus is to cater to the needs of the young lawyers who are dealing with arbitration matters at hand. So I think we'll open the floor for all the participants to take advantage of your experience and knowledge, sir, and ask questions on the subject. So all that a participant has to do is that they have to raise their hands and in a queue, while they are in a queue, one by one, we'll request everyone to ask a question. So we leave the floor open for questions now.
All right.
Yes, sir. Sir, I think till the time that somebody musters the courage to raise his hand, I will ask a question. So my question, sir, is
So
that once,
first of all, please, Fahad,
yes,
first of all, I would like to
yes,
tell them all that I wish
yes,
that all of you may put some questions, and I want you see you good budding advocates, because experience matters. For young lawyers, first 2 years are a matter of struggle. They have to fight for their existence, but they should not lose heart. And they start the practice, it is struggling, it is fighting. If you have to run after the people, you have to run after the cases. But the moment you make an impact, then people will run after you and money will run after you. Second,
yes,
this profession is a very great profession, it's a noble profession, provided you own it and dedicate, give 100% dedication. This profession has given so many rise, has given birth to so many great scholars, so many great jurists. Not only this, you have, when you are law graduate, you have multi-dimensional channels available to step in. You can go for the
yes,
judicial services, you can go for the executive services, you can go for the POship, you can go for the law officership, you can represent different adults. So there are multiple dimensions. There is no need to be depressed or discouraged. Keep
yes, sir.
commitment. You have to be very committed people, hardworking people. Then you will see the sky will be the limit for your success. Anyway, Mr. Fahad, you can continue your question.
Absolutely. Sir, in the meanwhile, I think your words have worked magic. We finally have a raised hand. Mr. Arjun Chawla has raised his hand. We'll request Mr. Arjun to ask a question, please.
Good evening, my lord.
Very good evening.
My lord, it's a dream come like true that I have interacted with Honorable Justice Yaqoob Mir, sir. My lord, I still can't believe that I am talking to you. My lord, today I was talking to my mother about this session, which was happening in the evening. So my mother told me that there was an order passed by your lordship in 2009 in CMI MA 348 of 2009 in our favor, which I am still using in the trial court, where the delay was condoned of 62 days with a cost of rupees 5,000. It was my personal case. I was a kid at that time. My mother was having maintenance under Hindu Adoption Maintenance Act, and luckily the appeal was delayed by of 62 days. My father was suffering from cancer, and my lords condoned the delay with subject to the cost of rupees 5,000 rupees. So it refreshed all those memories of 2009. Then when my mother used to come to the court and attend the litigation, and thereafter my father passed away, and no, my lord has been also elevated as chief justice. So my lord, during this process, everything has been changed, my lord. So my lord, I was a kid. Now I am doing LLB. After these years, I want to, my lord, ask that as a judge of the Honorable J&K High Court and thereafter elevated as a chief justice of Meghalaya High Court. My lord, what are the changes and the experience that my lord has faced in the life from 2009 to 2020, the COVID time? And when my lord was appointed first time as a judge of the J&K High Court, what kind of happiness it may come in the mind of a person when person comes to know that he has been appointed as a judge of court of record or constitutional court. Obviously, me as a law student, a great inspirant of your lordship, also wants to become a person like you. I don't know whether it is possible in my life or not, but I just also want to know that how will be an experience for a person when a notification signed by president gets issued that you are appointed as a judge of the constitutional court of the country, madam.
Right.
Please, my lord, because my life is
Okay.
affected with some way. My lord has given some order today which we are using in the trial court recently, that one application of 152 CPC has been dismissed by family court because of your lordship's order. If that order wouldn't.
Acha, thank you very much. In fact, so much, thanks for saying so many words. I don't remember anything what I have done as a judge of the High Court, but at least one experience I can share with you. As I have said in the beginning, that fight and struggle are key. And then commitment is very important, and hard work is very important for being a good, successful advocate or a very successful officer. See, I started my practice as an advocate in my own parent district, that was District Pulwama. Thereafter, I competed for higher judicial service examination, and luckily I qualified it. And my first appointment was as district and sessions judge in the year 1993. Then I had an experience of working as a district judge for about 12 years. Thereafter, I was elevated as judge of the High Court of Jammu and Kashmir. And I remained as judge of the High Court of Jammu and Kashmir for 10 long years. Thereafter, I was elevated as the Chief Justice of the High Court of Meghalaya. This was a very long journey and very sweet journey. But I will tell you one thing, while becoming the judge, three principles which I had adopted. First is that while being an advocate, I was very honest to myself. That's not any favor to anyone. One has to be so like that. As an advocate, I was always very honest to my client. Win or loss, these are two parts, hardly matters. You have to give 100%, then destiny decides what it has to decide. With that hard work, I also prepared this higher judicial service examination. Then I first appointment was at Srinagar headquarters. Then I continued there for quite a long time. But I found myself, I was just self-confident that whatever I have to decide while keeping in view that my Almighty is watching me. This has been my principle, that irrespective of caste, creed, color, anything, it has never touched my mind or never appealed to my conscience. Only thing which appealed to my conscience, that a human being was appearing in the court and I had to do justice. That is what was my concept. Then I was working very hard on the cases so that the party may not suffer. Humanly, whatever was possible, I was doing it to best. My own conscience. I was not pleasing anybody, but I was pleasing my Allah. And thank God, when I look into the retrospect, I feel a great privilege that you will not take it as a self praise. Self praise is no recommendation. But you forced me to say what was your journey, how you have risen to the post of the position of the chief justice. That thing motivated me, that thing forced me to divulge. Otherwise, no need, I'm not to score anything now. Because that time that time is over. So anyway, that's how I can tell you that this is the way how to, this can be a way of, this can be a ladder for rising. The way I was a simple advocate of Pulwama. I did my law graduation from Kashmir University, joined the bar directly at Pulwama. Then things, for 1 or 2 years, I was really fighting and struggling. Finally, things fell in line, and I was altogether a different person, a different advocate, and God was kind enough. That's how I had reached. But basically, honesty, commitment, then this profession, irrespective of cost, creed, call, any rank, anything. Thank God I have never been afraid of anybody except Allah while deciding the cases. That is the only key how I could reach to this position. Then there is a
So
role
that's
of
indeed.
that is the role of the destiny. The destiny was also in my favor.
Mr.
Otherwise,
Sheikh Hilal has also raised his hand. Mr. Sheikh Hilal, you can unmute your mic and ask your question.
Assalamu alaikum, sir.
Walaikum Islam.
Sir, thank you for giving me two vital opportunities in your during your tenure. Because of those two vital opportunities, I remember. Because of those opportunities, today I have gained some name because of you. I don't want to ask any question, but during your tenure, especially in your proceedings, you, whenever any advocate used to mum in his arguments, your honor would quote a line. I remember, and I still quote, whenever I feel, I also quote that line. Ah ko chahiye ek umr asar hone tak. I want to hear this line. What was the meaning behind? Though I know the meaning of this line, but I want to hear from you, sir. What was the hidden meaning behind this line, sir?
That was simply to encourage the advocate that try
Yes,
to work very hard so
yes,
that
sir.
you can have an impact on the field.
Yes, sir. Yes, sir. I understand.
When,
I late.
when you pray to God, sometimes some moment is such which is accepted, which is heard, and
Yes,
you
sir.
are bestowed, you are blessed. That's what
I'm
I
very
like.
I am very thankful to you, sir, for giving me those. I remember, sir. I have quoted that. I whenever I talk with any friend, I quote the those vital opportunities which your lordship gave me at that time when I was still growing my practice. Thank you very much for that, sir. Thank you very much for that.
Thank God you have groomed, you must groom, and God will bless
I am still growing, sir, because of your blessings, sir. Thank you very much, sir. Thank you.
you.
So now we'll take our next question. I believe Mr. Iftikhar Hassan Samun had raised his hand. Mr. Iftikhar, if you still want to ask your question, you can please go ahead. So in the meanwhile, sir, I have a small query, sir.
Please.
So with regard to the Arbitration Act, sir, there are provisions, Section 8, where a court can can refer the matter for arbitration, and then of course there is Section 11, which gives the courts of record a power to appoint an arbitrator. So usually, sir, what happens is a Section 8 order by, say, a district court or any other civil court before whom a matter which is otherwise arbitrable is brought, a reference generally is made to a specific arbitrator, wherein the arbitrator is also appointed under Section 8. So my confusion, Your Honor, is that because the power of Section 11 is limited to certain courts only, can a court of reference under Section 8 appoint a specific arbitrator while giving the reference?
In fact, basically, there is a provision in the Civil Procedure Code which provides for, because Legal Service Authority Act provides for alternate dispute resolution. There are four methods involved, which include arbitration also.
Yes,
So
sir.
while you are filing when a suit is filed, before you file the defense written
Yes, sir.
statement, you can request a court for arbitration. There is a power given to the court, but however, just all matters are to be supposed application for interim relief, application for injunction, application for Section 17. Those are all powers with the principal court of jurisdiction.
Yeah.
That court power in that. But
Yes, sir.
initially, when you are before the civil court, there is a provision. Before you file the written statement, you can just say there is an arbitration clause. It may be referred to the arbitrator. Here is simply a reference.
Yes,
Just
sir.
all powers are with the principal.
So at the time of reference, sir, can the court also appoint an arbitrator?
When reference is there, arbitrator is automatically appointed.
All right. So the power of appointment of an arbitrator is within the contours of Section 8 as well.
It is within because of amendment in Civil Procedure Code as well as in your Legal Service Authorities Act provisions.
All right, sir.
But the jurisdiction to deal with all ancillary matters lies with the principal
Lies
court
with
of Solvency,
principal.
as well as that, which includes that.
That was very
Mr.
helpful.
Tawfiq Malik has also
Mr.
raised
Tausi,
his
yes.
hand.
Yes.
Kindly unmute your mic and ask your question. Mr. Tawfiq Malik. Until he asks the question, there is an in-call message, I guess. Mr. Iftikhar Samoon has written, Assalamu alaikum and a very good evening. Kindly do read this out to our most esteemed guest. Unfortunately, due to surrounding noise, I'm not able to ask through video or audio as it would be disturbing. So I would like to state on record here. It is our absolute pleasure and privilege to have you here, sir. You, as a son of the soil, have made us all proud with your dedication, hard work, brutal honesty, and by upholding the rule of law, all while being a thorough gentleman. I would like to ask only one small question. If there is an arbitration clause at the sole option of one party,
You please repeat it.
if there is an arbitration clause
Hmm.
at the sole option of one party, is it legal to preclude the party?
No, it can't be. Basically, it can't be sole arbitration. Arbitration agreement. For a dispute, there are two persons required. Arbitration can be referred with the consent of the parties. One party can ask the other party, will appoint the arbitrator, give him the notice. If he doesn't respond, first of all, let the concept be clear. If there is no arbitration clause, parties can issue notice to other party where we have dispute. We want it to be settled through arbitration in view of the arbitration clause. Please respond to my request. We'll send it to the arbitrator. We'll appoint the arbitrator. We can appoint the arbitrator. There is no objection. But now the question, other side may not respond to it. Then in that eventuality, they will go to the court. It can't be a sole dispute is between the two parties. Whosoever we agree with, that party will ask for the arbitration. It can't be a sole person who can arbitrate because it makes two to make the quarrel also. How can
Yes.
one person? Both the parties have a right. If one party has have a more than he can issue a notice as a procedure. We will issue him 30 days notice. Please come and this is my request. We will want to settle this dispute to arbitration. We'll appoint two arbitrators. They will solve any problem. If he doesn't respond, then he has a remedy of going to the court.
Yes, sir. Sir, he's writing that he is obliged to receive the
My thanks
Mr.
clarification.
to
Tausif Malik, you have unmuted your mic now. Can you please
thanks to
ask
him
the question
because
you
he's a
want?
budding young lawyer. Let him know.
Yes, ma'am. Assalamu alaikum, everyone.
Walaikum
Hello,
salam.
sir. Sir, I
Yes.
have been in legal. My question is outside the scope of Arbitration Act, Arbitration and Conciliation Act. I am a fresh advocate and only having 4 years of practice, and I am dealing with majorly the criminal law and with criminal cases.
Mhm.
So most of times in criminal cases, we when we plead before cases, we when we plead before judges, the decision of like in bail matters, there lies a vast discretion of a judge to in deciding a case. My simple question is how to win discretion of a judge. What etiquettes must a young advocate have so that he can win this discretion in his favor, so that he can be a good lawyer?
All right, right. Discretion basically is a power which is not untrammelled or uncontrolled. Discretion has to be exercised on well-settled principles of law. There can be no question of junior or senior or anyone else. If you have a good case, you can make out a case for exercise of discretion. That the honorable judge will automatically exercise his discretion. He cannot be harsh against junior or the senior. He has to be equal to all. But question is how you will plead and how you will make out a case before the court that I have a case where in which demands that discretion shall be exercised in my favor. The general concept is when there is young lawyer, he wants immediate relief, immediate so that he may have some impact in the field. Otherwise, client is always shaky. He never trusts him, never believes him. And now, in case he gets some relief immediately, he develops trust and more clientage comes to him. Now, your question is a bit twisted one. Purpose you feel that the discretion is not being exercised in your favor. I think you have to work hard and um, impress the court with your arguments, make out a strong case. You will find discretion will definitely be exercised. Are you
Mr.
satisfied?
Thank you so much, sir.
We also have Tariq Malik. He has raised his hand. Kindly unmute your mic and ask your question. Mr. Tariq Malik.
Assalamu alaikum, sir.
Walaikum salam.
Sir, there is section 11 in Arbitration and Conciliation Act which refers to appointment of arbitrators. Sir,
Correct?
sir the
Yes.
point here is that if there is an arbitration agreement between two parties, whereby one party is given authority or the power, we can say, to nominate a sole arbitrator instead of appointing an arbitrator. Is it legal, sir?
What is the agreement clause?
Sir, agreement clause is whenever there arises any dispute in between the parties, sir, the matter will be referred to a sole arbitrator that will be nominated by one party.
That is correct. There is no harm. It is an agreed term.
Is it correct, sir?
It is correct. Both the parties have a right. One party can appoint when there is already agreement.
No, sir. The word used there is in arbitration clause. The word there used there is nomination, sir.
Please
Instead
listen.
of appointment, sir.
Please listen. Section 11(2). Section
Sir.
11 clause 2 says the parties are free to agree on a procedure for
Sir.
appointing the arbitrator or arbitrators.
Sir.
Wording of section is clear that they are free to Now, if they have evolved a procedure, they are free to do. It is an
No, sir.
agreement.
Point is there is a difference between appointment and nomination, sir. Uh,
The nomination in stricto sense will be deemed as an appointment because they have agreed for this.
Sir.
See, arbitration is role of the arbitration is the agreement between the two parties. First, there must be an first point is there should be a clause, arbitration clause. When arbitration clause is there, then the method and procedure that is for the parties to evolve. If they have already settled in the agreement that we will have, if the dispute arises, such and such person can be appointed as a sole arbitrator. He has to be appointed as a sole arbitrator. There is no problem in that. You see, in some
Obliged,
cases,
sir.
there are some in engineering department that say that if any dispute arises, it shall be resolved, decided by the chief engineer. So, sole arbitrator. It is an agreed
Mhm.
forum. Once it is agreed, there is no difficulty. Section 11 who itself provides on agreed terms.
Okay. Oh,
Nomination or
obliged,
appointment. One and the same thing.
obliged, sir.
Also, sir, we have an in-call message from Umar Wani. He has written, Assalamu alaikum, sir. It was a privilege to appear before you 8 years back in numerous cases where one would be asked to make out a case for interim. That was a great ignition for a lawyer, essentially youngsters like me. My question is brief. Is it not unjust to deny the remedy of Arbitration Act if the written statement is filed? I'll repeat the question, sir. He has written,
I
is it
got the
not
point.
unjust to deny the
I got,
remedy of Arbitration Act if the written statement is filed?
I got the point. Basically, then law is to be amended when civil procedure code provides for it. Then no option. Maybe it may be unjust. If a party wants it to be settled through mediation, through arbitration, but there is a bar, technical bar, he has filed written statement. Party has to be very careful. Before filing written statement, you should have well the person. Now, if he has not, his question is, will it not be unjust to preclude him from referring the matter to the arbitrator? But law is law. Law has to be followed as it is. Until and unless law is in statute book, it has to be followed, or till it is challenged or struck down by the High Court. You cannot deviate from the law.
Mhm. All right, so we also have another in-call question that is from Dawood Bhatt. He has written, Assalamu alaikum. When there is an arbitration agreement and a dispute is there, one party didn't agree to appoint arbitrator. The section 11 is moved by one party, but it has been observed the party are playing delay in filing reply. A result in delay the matter by one way or another way. There
Is delayed,
is there
object is
not a
delayed.
need to address this issue by legislature?
Very correct.
This is not an issue that is to be addressed by the legislature.
Not required to be addressed by the legislature, but it has to be taken care of by the court itself.
Mhm,
Because there is a provision if a party delays the proceeding, court can impose heavy costs.
mhm,
Court can compel him to file it, or court has power to close his right and appoint arbitrator. Now it depends, in court there is a volume of work, lot of work. Sometimes case gets disturbed, sometimes it doesn't get disturbed back because of that it gets delayed. But our provision is there, inbuilt provision is there. Even if a party delays or avoids or prolongs, what is the remedial measure available? And there is a section provided under the Act. Court can heavily impose costs and
mhm.
close his right and appoint arbitrator. It is not that
There is
he is
al-
not.
that's another in-call message from Nazim Khan. He has written, Salam. It was an absolute pleasure to see you after so many years. Vividly remember arguing revenue cases in your court and getting so much to learn. Allah bless you with good health and happiness.
Thank you very much.
And we also have someone has raised their hands.
Mr.
Uh,
Zahur Bhatt,
okay, Mr. Zahur, but kindly unmute your mic and ask your question.
Assalamu alaikum, sir.
Islam.
Sir, it is good to see you here at this podcast program, sir. May Allah
Yes.
bless you and Allah aapko salamat rakhe, sir. I have also a question, sir, vis-a-vis this. Sir, if two parties have entered into an agreement for arbitration, in the clause is there, sir. If a dispute will arise, they will go for an arbitrator. And accordingly, they have appointed an arbitrator, sir. Private person. So, the private dispute, they have appointed a private person as an arbitrator, sir, and he has resolved the dispute. And finally,
Right.
he has passed the award, sir. Sir,
Correct.
for having this award as an effective degree, sir, what the arbitrator is obliged to do? He has to register this award, sir, or he
Not
has to submit
necessary.
it to. So or
So
he
he
has to
has
submit it before the court of law. So previously it was the first making a figure rule, the rule of law, sir. Is this
earlier, earlier it used to be like that. Now it is not that. Earlier it used
right,
to
sir?
be that award, it was the made rule of the court. Now it is an non-arbitrary scope has been widened. Therefore, if the two parties have, it will have a force of a decree. It has to be implemented as a decree.
So it, sir, assume the status of a decree, sir. Even if he has
Yes.
resolved the dispute, sir, automatically, sir,
No,
he is not required to register it before the sir. Say,
not,
as sir, I have seen,
not,
sir, previously,
no,
sir,
not,
and arbiter is going before the registrar, sub registrar, and he's submitting that award for the court. That sub registrar just getting a registered, sir. Now, sir, where it lies,
not
sir,
necessarily.
it's not necessary,
It,
sir, as per Arbitration Act, sir.
it is option, or it is option.
Right, sir.
It is optional. You may get it registered, but registration ipso facto is not imperative. Once dispute is resolved, award is passed, award assumes the character of a decree, and it has
Yes.
to be enforced.
Sir, one sir, a unique sir, situation has arisen, sir, because of the 2015 flood, sir. A matter has been resolved by the arbitrator, sir, but that award has been washed with the flood, sir. Because he was a private person, he cannot kept any record with that, sir. Now we have a photostat copy, sir, which we have submitted before the court, sir. And the Honorable Court has already, sir, rightly directed us to get those this arbitrators who have resolved this dispute before the court of law, so that they will attest this copy, sir. So if they will make us
That is right.
they will depose a short statement, sir, then there is no question to challenge that award, sir. Is it correct, sir? That to that extent, sir?
Absolutely. Absolutely correct. If he says there is no question, he is not challenging that has not been challenged. There is a time limit for challenging the same. He has not challenged it. It is already fine. Now the question was washed out by the flood. That does not mean that the roots are totally. It is approved. When you have a certified copy or photocopy, he can come. Arbitrator can come and certify that yes, he has given award. Then there is no
Yes.
difference. But
Thank
see, law and Arbitration Act has to be interpreted in a pragmatic manner so as to give it its own effect and teeth to work. It is not that one
right,
that it's a justice-oriented procedure. It cannot
right,
be
sir.
somebody,
I'm saying, sir.
somebody has taken too much of exercise. Thank you. Thank you for the question.
Thank you, sir. Gracious, sir. Thank you, sir. Thanks.
I don't think that
Yes.
we have any more questions. We have an in-call message, but I don't think she has. Yes, ma'am.
Proceeded to
Yes. Mr. Gaurav Salot. His question is, Your Honor, I have just started advocacy last week. My question is related to Prevention of Damage to Public Property Act 1984. Does additional munsif has the power to grant bail under PDPP Act 1984 under Section 3? Because due to pressure, I failed to provide the judgments to my Honorable Additional Munsif Judge regarding the matter.
No, this act, I have not gone through the act. What is the act? Whether there is procedure? See, if the case bail matter is normally governed by criminal procedure. There are clearly specified categories of magistrates, categories of different judges. It is earmarked which court has a jurisdiction. Normally, court which has power to commit or try the case has a jurisdiction to grant the bail. Now, I don't know what is the cause and what is the punishment prescribed under that. Accordingly, it can be decided which court has the jurisdiction to grant.
Sir, I think probably Mr. Ashok Bhan wants to ask a question. He has kept his mic unmuted.
Mr.
So, Mr. Ashok,
Mr. Ashok Bhan is a person who has been practicing with me at Pulwama for quite a long time. A very good friend of mine. I
all
wish
right.
to. All right, please ask Mr. Bhan.
I think he's taking the liberties of being an old associate, sir. So he is probably yes,
I
sir.
think he's a mute power.
Mr. Dawood Khan has raised their hands. Mr.
All
Dawood
right.
Khan, kindly
Mr.
unmute
Ashok
your
is
mic.
on. He has not said
Yes.
anything.
Am I audible?
Yes,
Yes.
you're audible.
Yes.
Assalamu alaikum. Good evening, my lords.
Islam.
Yes. Sir, my question is you were just 35 when you became the judge, and district court is the highest appellate court in the district. And considering your extensive experience in dispensing justice, like when you left the court at the 63, like it must be like you served the society for nearly about in dispensing justice for nearly about 3-4 decades. So considering your extensive experience in dispensing justice, how have your perspectives on fairness and equity evolved throughout your career? Like definitely there must have been like some change, like when you entered the judiciary. There was there any change, or it remained static, or sometimes when you also had the you were also the judge of the high court for nearly about 15 years in a constitutional court, and uh, was there sometimes did you felt the need to balance like the balance to balance the legal precedent with adopting to evolving social norms and expectations? That I hope I was able to you know uh, put my question in
Yes.
the right words.
Anyway, I got your question. I got your question.
Yes, sir.
It is true. Equity, High Court is normally court of equity first. When you exercise writ jurisdiction, equities have to be balanced. Equity's object is to balance and to advance the cause of justice. And there are various equity we are to be satisfied. If a person comes to the court with clean hands, he has to be clean to the court so that he may get some more money. Question how to balance? It depends. It varies from person to person. Definitely, when you are sitting on the other side of the bench, and as an advocate, you have shifted to other side of the bench, experience altogether different. When you are an advocate, you are free to make any submission, relevant submission. Maybe it may be connected with the facts, it may be connected with the laws, or sometimes there can be abrasion here and there. But when there is a judge, he has to balance both here, both the sides, then see whatever separate the grain from the chaff. What is the best that is to be done? While doing so, sometimes law has to be interpreted where there is a scope for interpretation so as to advance the cause of justice. I think your question purpose is this: how to balance it. One has to be fair. We cannot just be courteous to anybody. We have to be fearless. We have to be fair in while dispensing the justice. That is the basic goal is to achieve the justice. Yes, I had an experience. I had at times very head shaking for various cases, how to do the justice in the case. And whatever was everybody with the honorable judge is doing a lot of homework, then going through files, reading law, and then only then you can find the judgments in the journal and you get the judgments. That is primary job is to he has to be answerable to Allah, and then he has to do the justice. That's possible justice. And one must have no doubt about it.
So we
Thank you
have
so
we'll
much,
take
sir.
there's another in-call question from Mr. Sajad. He has written, Sir, in settlement of the accounts case, wherein the court appoints the commissioner with the consent of both the parties, and before the commissioner, one of the parties has not participated. Accordingly, commissioner files the report before the court, and the court passes decree on the basis of the commissioner's report, wherein only party has participated. Sir, is that decree valid in the eyes of law?
It has to be seen under what circumstances court, whether court has, see, whether the moment commissioner was appointed, he has submitted, the other party has not cooperated, he has submitted his report. Court has to deal with that report. Maybe court may issue notice to the party that I have appointed the commissioner, you did not participate. Have you any objection to it? After satisfying about his objection or no objection, then he can pause the orders. It
All right,
depends.
sir. Sir, we have
Uh,
another question. Yes.
yes, not question. It's from Nirbhay Sharma. He has written, Good evening, sir. My question is not about a certain topic. I wanted a career advice from you, sir. As I'm a first semester LLB student presently, what he's asking what things I should adopt or avoid at this stage of my career's beginning. I want to become a judge and serve my nation. Please bless me with your beneficial advice.
Yes, please be true to your studies. You are in first semester. Complete your studies with this determination that I have to achieve something and give 100% by the go for a extensive study of law. As a student in universities, you will get only a concept of law. After gaining that concept of law, when you will come into the actual practice, you will find a different world. Then you have to have an adaptation with that system also. Once you are able to have an adaptation with that system, then you will automatically, your personality will change, and you will understand how to interpret the law, how to plead the law. Then you have to work very hard. You want to become the judge, that is in the hands of Allah. You put in, you work hard, then Allah will help you. Because nobody has seen his destiny, what he is going to happen, what is going to happen. Maybe it may be in his destiny to become judge, he will definitely become. But for that, whatever is required by him is complete commitment and hard work.
Thank you, sir. Indeed, it's a matter of destinies, and we have been very fortunate today, sir, to have a person of your caliber as well as your standing to shower his magnanimity with us by giving us more than 1.5 hours of immaculate and invaluable advice, sir. Thanks a lot. Thanks a lot for giving today's
God bless. God
lecture.
bless you. God bless you.
I'm sure all the participants will make full use of the knowledge that they have gained from both your knowledge as well as experience, sir. And a very warm thank you on
Thank
behalf
you.
of the entire team of Codecast for this lecture, sir.
Thank you.
Thank you
Thank you.
so much, sir. Thank you so much for coming in a very short notice of time. Thank you so much. I never thought you'd say yes to me, but thank you so much for being such a
When, I,
polite personality.
when a young daughter has requested, I had no option but to say yes.
Thank you so much, sir. It
Thanks
means
a
a
lot.
lot. It really means a lot,
When
sir.
I
It
saw
really means a lot.
when I saw Mr. Fahad also there, he is like just like a child, my child. So I was happy to see him here
Absolutely, sir.
also. So
It's
my
a
good
complete
wishes,
honor. Sir. It's a complete honor
my,
that you remember me. It's a complete honor, sir.
my good wishes to all the participants. May God help them. And grant my advice. Please be confident, work hard. Sky is the limit.
Thank you, sir.
Thank you very
Thank
much.
you
And
so
we
much. Thank you so much, sir. Thank
God
you so
bless
much.
you.
Thank you so much, sir.
highly
Thank you.
obliged, sir. Thank you. We'll surely need your guidance in the future as well, sir. So I'm sure we'll have
Definitely,
you again sometime. Thanks a
definitely,
lot for
definitely.
today's.
Inshallah, God willing, I'm very glad. Thank you very
Thank you. Thank you.
much. That's a fun.